Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be tackling what I believe to be the single most important issue facing Canadian unions today. And that is the payroll system under which their membership is operating. And this really largely applies to Canadian employees and has become apparent to myself from analysis of far too many collective bargaining agreements in the province of Alberta. And it also would appear to pertain to provinces outside of Alberta. And what is this great payroll issue that I'm talking about? It is the fact that collective bargaining agreements have become very generic and common. It is the fact that payroll systems, payroll software, and payroll calculations typically emanate from outside the province within which the employees work, and as such do not reflect the employment standards legislation of those particular provinces. So what we have to remember, first of all, is that in Canada we have 10 provinces and we also have 3 territories. And in each of those provinces, they have their own unique and distinct employment standards legislation, which dictates with very unique and distinct manners how calculations are done with respect to payroll, from overtime pay to vacation pay, statutory holiday pay, and termination pay. And for certain federalized employees, we also have the Canada Labour Code, which provides another formula that is distinct from the other provinces. So even though you might be operating in the province of Ontario, if you're subject to the Canada Labour Code, you have a different calculation methodology that operates. And how does this impact union employees? And how is it discernible from collective bargaining agreements that exist for those union employees that there is such disarray, such underpayments that would appear to be occurring with respect to those union employees? Well, first of all, we look at the software. And payroll software typically emanates from the United States. It is brought to Canada, and slight modifications are often done for the province of Ontario. The question is, are all those modifications being done subsequently for each of the other provinces? And what the collective agreements show is it would appear that they are not being properly done. I could be stand to be corrected in certain instances. But why would it be that the collective agreements for various provinces are not consistent with their laws of that province and within which the employee is working, but may well be appropriate in, let's say, the province of Ontario? Probably because these collective agreements are templated and they're worked on by lawyers in Ontario. And Ontario lawyers may well know the laws of Ontario, but they don't necessarily know the very specifics and nuances of other provinces. And by not operating on that basis and not integrating those aspects, they oversee and they miss aspects that are critical to unionized employees in other provinces. Because they're not everyone operating in Ontario. And if you're not operating in Ontario, you're not subject to the laws of Ontario with respect to payroll calculations. And similarly, if you're a federalized employee who's subject to the Canada Labour Code, even if you are operating in the province of Ontario, you are not necessarily subject to those specific laws. But now you're subject to a different set of laws known as the Canada Labour Code, which has a different computational methodology that needs to be addressed. Now, I know it all sounds complicated. It is somewhat complicated because you have to go back to first principles to understand where I'm coming from. And unfortunately, the lawyers, the union negotiators that represent you, they may very well be doing a very good job. They might not have the mathematical insights or recognition of what is happening. And what we're hoping with this video is that we'll open our eyes to a lot of those union representatives, a lot of those lawyers, to take a second look at the mathematical computations that their particular province requires them to take a look at. Because once you start looking at this, and you don't simply work with a template, that in truth, many of these templates are extensive, 100-page documents that have been very standardized and consistent. But where negotiations focus on a 2% increase, a 5% increase here or there, they don't look at the technical legal aspects. Even though oftentimes at the very beginning of the collective agreements, the agreements say they have to follow the laws of the province. And this is a non-negotiable aspect. And the statutes are non-negotiable in a sense too. So that when you actually redo the calculations, you'll see that oftentimes overtime pay, vacation pay, statutory holiday pay, and termination pay at a minimum are being incorrectly calculated. And who suffers it from it? Unionized employees. Because the calculations are all too often being done on a calculation methodology that is providing numbers that are less than what you are legally entitled to as a union employee, as any employee in that particular province. So you can't simply say, I'm going to rely upon what the collective agreement has been for the last 10, 20 years. You really need to take a look at it. You need somebody who has knowledge and insight to take a look at it. Because if you're losing $2,000, $5,000, even upwards of $10,000 or $20,000 a year, for those individuals who put a lot of overtime in, and in certain provinces like the province of Alberta, you could be losing substantial amounts of money that are due to you, that you have legally earned, and you are able to collect upon, but for the fact that nobody has brought it to your attention. And I'm not trying to discredit anyone in this process. That is not my intent. My intent is to bring light to a situation that has been for too long overlooked. And because the process seems pretty clear, given the fact that it's been done possibly for decades incorrectly, people have not looked at it any further. They have accepted the system, they have accepted the calculations, and they have let it go on year after year after year without even looking at it, recognizing that there might be a problem. But if you see that there could potentially be a problem, and from a union perspective, each union member could be out thousands of dollars per year, which is collectible oftentimes, based on different legal theories, statutory language, and the like. Should you not take the time to revisit it, to look with people who actually have perspective on this? It might be able to shed light for yourself. Because we're not trying to get anybody free money. No. This is hard-earned money that the union employees have worked for and are legally entitled by the provincial employment standards legislation or the Canada Labour Code to be receiving. And oftentimes that money is actually held in trust by the employer without anybody knowing about this. And it is their money, not their employer's money. It is the union employees' money. And what a great thing if the union itself would start to pursue this. Because they are just a function of their membership, a function of the union employees. And it is their money that needs to be pursued. And is there money that they are entitled to? So why not look into it at a minimum? Why not investigate this? Because if we're talking about tens of thousands of dollars possibly that an individual union employee might well be entitled to, should they not be receiving this? And should they not be collecting it going forward? Because if they're putting in all that overtime, should not be calculated correctly and paid correctly. The same goes to other payments that are statutorily mandated. So you got to look into this stuff, see if it's applicable, and see how best to pursue it. Because we're talking about earned money that the unionized employees have worked for, and they should be properly entitled to it and receive it from their employer. Thank you.